So I'd like to welcome you all to the September 5th, 2018 meeting of the Planning Commission. And Commissioner Lambert, could you lead us in the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Roll call.
Commissioner Lambert?
Here.
Commissioner Landers?
Here.
Commissioner McKinnon?
Present.
Commissioner Perry?
Here.
And Chair Fonda Bernardi.
Here. Okay. Can we have the Planning Director's report?
Good evening, Commission. Coming up, next agenda is October 3rd. We've canceled the September 12th meeting. So the next meeting after tonight will be October 3rd. On that agenda, we have the 1920 Oceanfront Walk project and 1828 Ocean Avenue. Those are two mixed-use housing projects. Then on October 17th, we have a housing project at 2002 21st Street. This is in the Pico neighborhood near Virginia Avenue Park. This project's been around for a few years, but that's a development review permit, track map, and EIR. That same night, we have a fence wall height modification at 1130 Pearl. Also, a resolution of intention for the next round of zoning ordinance cleanup items. Then on November 7th, we have the bowling alley project on Pico, 234 Pico. So there's a mixed-use housing project proposed on that site as well. So that will be before you on November 7th. Coming up for City Council, actually there's not a lot of planning issues before the Council for the next few months. One, though, is on October 9th, the adoption of the LUP. And then on looking out a little bit further, on December 11th, there's an appeal of a landmarks designation of a tree at 1122 California. So that will be going to the Council on December 11th based on current schedule. That concludes my report on upcoming items, but I wanted to take the opportunity to introduce our City Attorney, Lane Dell. Lane.
Thank you so much for letting me join you tonight. I will not be advising. I'm going to defer to Heidi, but I did want to come and say hello. I've been with the city approximately a year now, and I realized that I had not yet made it to the Planning Commission, so I wanted to come to meet you all in person to thank you for your service. The longer I am with the city, the more extraordinarily grateful I am for everyone who is involved in making Santa Monica such an extraordinary place. So thank you for your service. As you know, I'm well apprised of your issues as they come to council and as the city attorney's office works hand in hand with PCD on the issues. So very nice to meet you all, and thank you for letting me join you.
Well, feel free at any time to join us. Okay, any questions for the Planning Director? Oh, okay. No questions? I have a question for you. In the LCP that's coming up, have there been any substantive changes that we should be aware of? Is it everything is just going through like a knife through butter, or have there been other questions that?
I think the only, the substantive changes have to do with the outstanding issues that we identified where we were not in agreement with the Coastal Commission staff.
Right. Has there been any progress on that?
Yeah, I mean, I think that we're making progress, and I think our hope is that by the time we get to council that we will have agreement in concept on language and such, so we're continuing to work on that, but I would say there seems to be some good forward movement being made on both sides.
Okay, thank you.
Oh, I have one question.
Please.
You reminded me of something. Do the two projects at Oceanfront Walk and Ocean Avenue, they go to the Coastal Commission, right?
Yes,
Do they go
Mhm.
there after they work through with them?
Yeah, that's how the process works. They go and seek their CDP after the city process.
And if they make changes, it comes back here or not?
It does not, no. I mean, well, I guess if it's something that results in something that's completely different than what was approved, then it would have to be an amended DR, yeah.
Are they subject to the Housing Accountability Act?
Those two, I mean, I don't want to get into too much of a discussion.
Just as the commission
but-
is subject to the same law we are, is my question.
Yeah, I mean, the housing account, to the fact that they're housing projects, one of them is subject to the act and one of them is not, because they have a modification application. With
Right, but
it.
assuming we approve that, then, but the Coastal Commission would, not us, the Coastal Commission would be subject to the same act.
Yes.
Since it's
Well,
state
it's-
law, I would assume so.
Yes.
It's lucky we've got a lot of lawyers here tonight.
Yeah, somebody.
Would you like to talk amongst yourself about that?
Maybe you could look into it.
Yeah.
I don't think we have any reason to believe at this stage that the Coastal Commission wouldn't also be subject to the Housing Accountability Act.
Thank you.
Yeah.
Okay, any announcements from commissioners?
Yes, following the last commission meeting where I made some comments about the Transport Management Organisation, I got invited to a meeting, and as a result, later in the meeting I will ask that we put that on the agenda to have the Transport Management Organisation come as soon as possible and present to us directly without the filter of Mobility Manager or others, because it was quite striking, some of the things that I learnt, and I think we should put the sea back into loose. And that's one of the quick ways we can do that.
Okay, any other comments? Okay, let's move on. There are no minutes to be approved. We have one statement of official action, which you have before you, which is 18 ENT 0038, which is 2822 Santa Monica Boulevard. It's a project that we reviewed, just a few weeks ago, actually.
I'll move approval.
Okay, we have one motion to approve, a second to approve. Any discussion? Okay. Yeah, okay, we'll take a voice vote. Okay, all those in favor?
Aye.
Aye.
Aye, okay, it was unanimous. And let's move on to the item 8A, which is an appeal of a fence hedge ordinance modification, actually, and it's 414 California Avenue. So could we have a staff report? Oh, wait, any disclosures?
I was going to drive by today, but my neck gave out, so I didn't.
I drove by today at 5 p.m.
So I spent about 30 minutes down there a week ago, last Wednesday in the morning at about 11 o'clock looking at it. I live around the corner, so I walk past that on an almost daily basis or ride the bike past the area.
No. Okay, and I visited it this afternoon around 5:30. Okay, please.
Good evening, Planning Commissioners. My name is Ivan Lai. I am one of the assistant planners in the City Planning Division. I'm here tonight to present the appeal of a zoning administrator's partial approval of a fence wall hedge modification. The subject property is located at 414 California Avenue. Currently, there is a 7-unit, 2-story apartment building on the site. The lot size is approximately 5,000 square feet, and it's located near the corner of 5th Street and California Avenue. As you can see from the property location, there's multiple. There's R2 and R2 and R3 properties within the general area. They consist of a lot of multifamily buildings, either 2 stories or multi-stories. And on the south of that, there is also commercial properties.
Ivan, can I interrupt you for a second? For some reason, this was not working.
I believe it's not working today.
So
Okay.
sorry, the only thing that works is that, well, the screen's around, so the
Okay.
big screen doesn't work.
All right.
You could look away.
Please continue.
Thank you. On the next slide, as you can see in the yellow highlighted rectangular box is the subject property. And then from the bird's eye view, you can see the subject property with the yellow arrow, along with the other multifamily buildings within the subject, around the subject property. So tonight, the appellant, who is also the property owner, is appealing the zoning administrator's partial approval of a fence wall and hedge height modification to allow the following: a hedge along the front property line ranging in height from 6 feet to 6 feet 6 inches, as well as a 6-foot high wrought iron fence and gate within the front yard setback, that is. Also, a wall with a lattice fence ranging in height from 6 feet 3 inches to 6 feet 7 inches along the east side parcel line, and finally a 6 foot 6 inch high hedge and a 6 foot 10 inch high wood gate within the front yard setback. As you can see, this is the subject property and the hedge in question. That also shows the wrought iron gate. The wrought iron gate to the right of it that's existing at 6 feet. On the site plan, as you can see, it shows basically the location of the existing 6 foot high wrought iron gate, along with the 6 foot 10 high wooden gate. Also, as you can see, there is an existing hedge that ranged, like I said, from 6 feet to 6 feet 10 inches or 6 feet 6 inches. And let's see, as we continue. These pictures obviously show the hedge detail in the front, and then also the wood and wrought iron gate detail. You can see behind the wrought iron gate is the 6 foot 10 inch high wood gate. Also, the next slide shows the along the corner of the property where it's next to an alley, fourth court, that is. That shows the hazardous visual obstruction areas. From there, in terms of the context map, in terms of the study area, we looked at the study area within a 1 block radius of the subject property. And as you can see from there, and that's what is shown with the green lines, the green rectangular box, that is. You can also see in terms of the orange areas, denotes existing non-conforming fence wall and hedges, as well as the green area with the red rectangular box indicating the legal registered or modified fence, wall, or hedge located within the front setback, pertinent to the property, the subject property, that is. Next slide shows the street context along the north side of the California Avenue. As you can see, the areas that are marked with the yellow box basically shows the existing non-conforming fence wall or hedges. And then where you see at 519 California Avenue, that is the legally registered and modified fence wall or hedge located within the front setback. And along the south side of California Avenue, as you can see, is the other multifamily residence. So in order for the fence wall and hedge height modification to be approved, you must meet the following findings. Those findings are the subject fence wall or hedge will be compatible with other similar structures and is required to mitigate impacts for adjacent land uses. Second finding would be not to be detrimental or injurious to the property or improvements in the general vicinity. And third, the modification will not impair the integrity and character of the neighborhood. During the ZA meeting, one letter was received in opposition of the project. Ultimately, after considering the evidence and the public testimony, the zoning administrator denied both the hedge request along the front property line ranging in height from 6 feet to 6 feet 6 inches and the 6 foot 10 high wood gate, while the following modifications were approved. As you can see from this slide here, showing the front of the subject property, the fence was reduced the hedge was reduced to 4 feet 6 inches in height along the front parcel line, and that was indicative in terms of it being visually, not being visually obtrusive, obstructive, that is, to vehicles and pedestrians. And it also provided a visual screening and security for the residents of the apartment building, along with the fact that the hedge reduced at 4 feet, or reduced in height from at 4 feet 6 inches, would be compatible with the existing street character of the neighborhood. The next approval had to do with the wrought iron fence and gate behind the front parcel line within the front yard setback. That remains that same height. It hasn't changed in its existing condition. With respect to the 6 foot high wall with lattice fence on the east parcel line, it's shown on this slide here. It's on the bottom slide, and that basically shows the existing condition. And that was approved. The hedge wall and wood fence within the it was basically conditioned so that the portion of the hedge wall and fence within the 5 foot hazardous visual area would need to comply with the HVO requirements. That was a stipulation in terms of a condition that was added, that that portion be reduced and be removed or reduced in height. So on May 16th of 2018, the appellant, who was also the property owner, Dorian King, filed an appeal of the zoning administrator's partial approval of the proposed fence wall and hedge modification. The applicant has stated the reason for the modified request has to do with the security and safety concerns regarding an attempted break-in into the front unit on February 24th of this year. So the applicant's request involves the hedge along the front property line ranging in height from 6 feet to 6 feet 6 inches, a 6 foot high wrought iron fence and gate within the front yard setback, a wall with a lattice fence ranging in height from 6 feet 3 inches to 6 feet 7 inches along the east side property line, and a 6 foot high hedge and 6 foot 6 inch high hedge and a 6 foot 10 inch high wood gate within the front yard setback area. So in order for a fence or hedge or wall to encroach into the 5 foot by 5 foot hazardous visual area, the following findings must be met. However, staff was not able to meet the findings in the affirmative. The first finding is the characteristics applicable to the parcel that does not apply to other properties in the vicinity. Staff found basically that the lots in that area or in that vicinity were rectangular shaped lots. Some of them were approximately the same size as the subject property's lot. Others were larger, obviously. With respect to the proposed encroachment, will be designed to maintain adequate site view and or provide other design elements. Staff noticed found that creating the 36-inch height request that would encroach into the HVO area, that would become an issue regarding safety for pedestrians as well as for vehicles. With respect to the strict application, the third finding of the hazardous visual obstructions, the strict application of provisions of this section would not result in practical difficulties or unnecessary hardship. In that respect, in that respect, there's basically a limitation on the heights of the obstruction within the HVO area, and it's intended to protect the safety of the pedestrians. And then the last finding, the granting of the encroachment will be contrary to or in conflict with the general purpose and intent of this section. Goal number 7 of the loose document seeks to ensure walking and bicycling are safe and comfortable on all neighborhood streets at all times of the day. In terms of public correspondence, public notice was mailed out to property owners and tenants within a 750-foot radius. It was published in the Santa Monica Daily Press, and no public correspondence was received prior to this meeting. Staff recommends that the Planning Commission deny the appeal and partially approve the fence, wall, and hedge height modification based on the findings and subject to the conditions in the draft statement of official action. That concludes my presentation. I await any questions you might have.
Okay, are there any questions for the staff? Okay, hearing none. Sean, you have a question?
Yeah, I just thank you very much. I was just looking at the. I don't know if this is a relevant question, but the modifications, on what basis were the modifications granted? The modifications that you did grant, on what basis were those granted?
That had to do with the compatibility with the neighborhood, in terms of the heights of the hedges, as well as the aspect of being able to screen and protect, the height in general, just for protection of the tenants, as well as being, like I said, consistent with the surrounding vicinity, the surrounding neighborhood, that is.
Okay, hearing no other questions, can we hear from the applicant?
Good evening, one and all. My name is, I don't know if you can hear me.
Yeah, we can hear you fine.
I apologize, I got injured today, but moving past that, I've come here to ask for your help. For each and every one of you that'll be voting on this, I need your assistance. Why? As cited in some incident reports that I've filed with him and others that I haven't been filed but have definitely been lived through, as you are aware, Santa Monica, the character has changed somewhat in our homeless population. I have photos that you should be in your packet there of homeless people right next door to, or right across the alley, which you can see is a large alley, but nonetheless just loitering there, causing trouble and mayhem over the time period. I had a young lady living in the front unit, and I got a call at 12 in the morning, 12:30 in the morning, screaming that her unit was being busted into and somebody trying to get in. I rushed down there. I only lived 5 minutes away. I rushed down there. Fortunately, that fellow wasn't there. She screamed and hollered enough that the guy ran away, but he busted the window as he tried to get into her unit. Now, I spent the rest of the evening getting a piece of plywood and putting it over the window and closing it for her and assuring her that I would stay in the unit if she needed me, to feel comfortable. So I finally calmed her down. She felt better. And I was able to go back home about 3 or 4 in the morning. But ever since that time, it occurred to me that we needed a fence up there, something to deter this influx of, I guess, homeless people. I'm not going to put labels on them, but I can tell you, being in Santa Monica for over 70 years, the character of Santa Monica has changed. Definitely has changed. I've lived here. I know it. Nobody can convince me otherwise. And what has changed is that there's a larger homeless population, and some of them I'm afraid, are criminally orientated. As the guy that tried to break into the gal's unit, and these fine fellows that are loitering out in that area. So that caused me to reach in my pockets and put out money for a fence that did a good job. It's keeping the, shall I use terms again, the riffraff out of the way of hard, productive working people that pay their rent, pay the taxes, pay everything, that makes this city goes on and on and on. So like I said, I'm requesting your help to help me. Now, and Ivan pointed out here that the hedge height he feels is 6'6" or something, and they gave me 4'6". I'm asking, can it just come up to 5'5"? Something that a homeless person can't high jump over. It's a small request, just 1 more foot. That's all I'm asking over there. If you take a picture or show the alley again, you'll see that it's an extra wide alley. So this great concern about the, 2 cars go up and down this alley. It's not a single car alley by any means. So there's ample rooms for people to be able to see and witness there. I'm willing to go on the 5 foot each side of that northeast corner there, cut back on that, but the existing law is 24 inches. I'm asking for 36. Just something there, and there's more. If there's ever been an accident, Ivan, are you aware of any accident that's ever occurred there? I've had that property for 35 years, and I don't know of a single thing that's ever occurred there. Okay. My other modification I ask is that on the iron gate, there's a wooden gate behind it protecting Unit 1. Again, this was the unit where the girl was assaulted in her own unit there, or attempted to assault. You can just see there's a wooden fence behind it. And that's just added protection for her. She was very comfortable with that. It's behind the iron gate, so there's no visibility problems. It just protects her more. And that's why I'm requesting your help. Help me to help them, okay? It's just that simple. I'm just adding a little bit more, but it makes it easier. The wooden part of the fence is 36 inches there in the center of the property. So it's just the hedge height that I'm requesting, and all I want to do is to deter these fine fellows that are, it should be in a packet, everybody should have that, these fine fellows from having any thought that they can violate somebody's privacy. The report that the learned and wise staff member Ivan has done here, he went as far as 5th Street, but I'm showing you another property here. Ivan, have you ever seen this property?
So, wait a minute, Mr. King. We're not at that stage. You can't interrogate the staff on this. You can ask the question, but you
Okay,
can't answer.
this is 614 California Avenue, 2 blocks up from where I am, sitting in the identical corner property. And I don't think there's anything less than 6.5 to 7 feet all the way around it. Okay, so my modifications are just well within reason. It looks good. I looked at the property and I just see it fits right in. But that isn't my major concern. It may be your concern, but I'm asking for your help. Safety. I just need to have that safety. Now I'll get up at 12 o'clock at night again and rush down there if I get another report. I'm willing to do that. No problems asked. But I prefer to have a nice, quiet evening, as well as my tenants would too. So that's the bulk of what I have to say here tonight. Just small modifications to take care of Santa Monicans. Thank you so much for your time.
Thank you, Mr. King. Are there any questions for the applicant?
I have a question, sir. The Santa Monica Police Department has a service whereby they will come and look at your property and make recommendations for safety improvements. They do that in my neighborhood. I'm sure they do it all over the city. Have you tried that? Whether it's exterior lighting or, motion sensors, ways to increase the security of your property without building a fence.
Well, I'm sure one of them would be a fence too.
Well, not if it's illegal, it wouldn't be.
Well, illegal, what, 36 inches?
Well,
I'm allowed.
all I'm saying is it's a recommendation that the police department does have that service if you wanted to avail yourself of it.
Okay, that's a valid point, and I appreciate that information. Any questions?
Any other questions?
Yeah. When was this fence installed originally? In the staff report or in the report, it suggests that it was about 10 years ago. Is that correct?
Yes.
Was that as a result of a series of incidents at that moment?
Yes, that was the straw that broke the camel's back when they tried to get through her window.
Wait,
glass window in the front.
No, 10 years ago, you mean? So when was the wall installed? The wall and the fence originally?
About 5 or 6 years ago. I don't know the exact date.
That's not what's in the report. It suggests it was 10 years ago.
The report dates are off, but I'm giving you the events that led up to the wall being there.
So prior to the wall and the fence being installed, you had problems?
Yes.
So,
yes.
But you haven't referred to those, and we don't have any police reports.
Well, I showed some incident reports that have happened since then. I was availed of that. I needed those numbers, or incident reports they're called, incident numbers, by Ivan. And I said, okay, I don't have any with me, but let's see what happens. Guess what? 2 incidences occurred between that time frame. Which numbers I submitted to the Planning Commission. So things have happened even since then. But fortunately, no one's busting into a unit right now and accosting some poor young female.
Why did she call you and not the police?
I gave her my safety number and told her that if she had any problems, get in touch with me ASAP.
So I live in a rental property, but I would never think of calling the landlord ahead of the cops if someone was breaking in.
Well, yes, she could have done that. She probably did do that. But the point was,
and this is the
she
same.
Told me, and I came down there.
But this is the same wall that someone got over the top of.
No, the wall came in after this incident. I put it up after this gal was assaulted.
5 years ago or 6 years ago?
Yes.
I see.
In response to her, for her safety. That's why I'm asking for your help to let's keep it safe.
Thank you.
Any other questions? I have a few questions. Sean, please.
So I'm aware of what I heard your description of the folks in the alley.
Yes.
Are you aware that the city has 2 teams, homeless multidisciplinary teams, that you can call the city and let them know that there are people about whom you may be concerned, for whom you may be concerned, and that they will come down and speak to them and find out how they can be helped.
Well, on these two incidences that happened in that time frame, since I filed this report, I've called the police and I've had them come there. One of them was they threatened to beat up another tenant of mine. If I hadn't showed up like that, that would have been a hell of a mess.
And those were the people in the alley?
No, these are different individuals that are just loitering out there. That other individual was described in one of the reports. He's just a Looney Tune on a bike that threatened one of my tenants. I showed up and told him back off. He backed off. We called the police immediately. They showed up, and by the time they got there, he had already meandered down to Fifth. Between 5th and 6th, there's an alley, and he went down there.
But you're unaware of the housing status of that gentleman?
Well, by looking at him, it was easy enough to determine he's probably a homeless person. You know, all he had was a bicycle with a big basket in front of it and looked like all his earthly belongings.
And do you have evidence that it was homeless people who were attempting to break into the apartment?
Criminally orientated people, homeless or otherwise, I couldn't tell you. From the gal thing, she just described him as a, she didn't really have a good description of the guy, to be honest. He was African American, and I don't know what else she could tell me about him in that regards. It was more like calming her down and getting her nerves back into order, that making her feel a little bit more secure. That was my number one goal when I was there.
I'm sorry she had to go through that.
Yeah. It's happily to report.
So I'd like to go back. The Planning Commission report that was given to us says on page 11 that the incident that you're referring to happened this year, but now you seem to be saying that it happened 5 years ago.
Oh, yes. With the girl that the unit was broken into, which precipitated me building the wall and gate there. That happened 5-6 years ago. The incident reports now is just showing that there's a proof to Ivan. I mean, I've been telling you right now, Santa Monica's changed. Here's some proof. The incident reports that I filed there.
So the wall hasn't deterred attempted break-ins.
It's deterred them from coming into a girl's unit. That's for darn sure, and that's why that wall's up there, and the gate now to help protect the rest of the tenants.
So what are the security incidents then that have been occurring?
I'm sorry, say that again.
What are the security incidents that have been occurring?
Other than the incident reports I've filed here?
I don't know what they are. I'm trying to get to the bottom of what are the issues that you've got that you say keep reoccurring.
Well, without a wall and so forth, every transient in the world can walk right through.
Please, that's not the question. My question to you is, you keep saying that there are issues of security and attempted break-ins. What are they?
What are the issues?
The Planning Commission report says that on March the 13th, there was an attempted break into the front unit this year. Is that correct?
No, it was 5-6 years ago.
Okay, so the 24th of February, a disturbance call was made. What was that about?
Well, it's one of those two, either where the guy attacked the tenant or the I'd have to look it up. I apologize, but both incident reports should be on the incident report.
So we don't have the incident report here, and that's why I'm asking you. So are there a sequence of security problems that happen every month, or is it once a year? How often does this happen?
There's no set time frame, but I can tell you that I feel safer, my tenants feel safer, if we can keep the hedges and the gates.
But you are saying that you're prepared to go down at least 1 foot.
Yes, that's a modest request. 5'5", nobody's going to high jump that. At least you've got to get this. If somebody really wants to get in a place, they'll get in. That's understood. But what you have to do is create a thing like the fences there. It's telling people subliminally, hopefully, if nothing else, that, hey, we don't want you, you're not supposed to be here. This is private property. This is somebody's apartment. You know, please stay out. You have doors and windows and you close them because you want that there.
So I guess what I'm trying to get at is
Yes.
the zoning administrator gave you a certain height, and you've asked for another foot of height,
Yes,
and you
please.
say that foot will make all the difference in deterring people, including homeless people, from attempting to break in, assault your renters, and so on. Is that correct? Is that the argument you're making?
Yes, to the extent that that 5'5" thing, 5'5" height or so, that nobody's thinking in terms of jumping over it. There's the bushes, you know, you're going to go into the bushes, etc. 4 foot something, you know, or 36 inches is the wooden part of the front there. That can be stepped over. But 5'5"
Well,
is something to make somebody think twice about
Not
climbing.
sure that it can be stepped over, to be honest. Yeah, it may depend on the height. You're a bigger man than I am.
Well, they can sit on it and.
But
and
thank
go
you
the other
anyway.
way.
Thank you.
They're not going to sit on a 5'5" high wall. And it's just like I'm saying, all it's doing is just saying, back off. Yeah, you know, leave the tenant alone. So please, with your help.
So I'd like to continue with some questions
Sure.
that Commissioner McKinnon started. Let me understand it. The 3-foot-high wall that's in front of the property,
Yeah, the light fence.
is that something that was built nominally 10 years ago when this incident happened, or was that pre-existing way back when?
All this came to be, it was wide open in the front there.
I see. So nominally 10 years ago when this incident occurred, or 5 years ago, you put up a 3-foot-high fence along the front and you planted the hedges that we see there today.
Yes.
Is that correct? And then somewhere along the way, roughly in the same time frame, you built the iron gate. That's the one that's there with the
Okay.
spiky tops. And then you built the other gate, the wooden gate that separates the front patio from the side walkway. Is that correct?
When the wooden fence went up, the wooden gate went up over there
Okay.
too.
And
The iron gate came in later because I had an incident, which I didn't take an incident report. It was before all this happened, where a guy, where the iron gate is there is a walkway to the tenant access. And we had a homeless guy sleeping upstairs outside of a couple units, upstairs of all places. And I called the police. They came. He left 2 credit cards there. So I gave those to the police officer. I didn't get an incident report on that. But you can imagine what the tenants were feeling like, you know, coming home at night and seeing a guy sleeping, you know, before their doorstep. So, of course, I get this information the next day and the guy's gone. But they're all looking at me, what are you going to do about it? What are you going to do about it? I said, well, let's put up a gate. Good iron gate, 6-foot gate. You know, if you really want to climb over it, you can get over it, but it just deters that. And I haven't had a single sleepover in the front door area since then. And the
Okay.
gate was approved. I mean, it's nice. It works.
okay, and can you tell me about the fence that's along the east side of the property? Has that always been there? Yeah,
There
that.
is, you can see the lattice woodwork. I made it lattice so and holes through it so you can look through if necessary. And the lattice is at top, excuse me. The wooden plankings there, I made them, I didn't do straight like this. I opened them up a little bit so, you know, there's view there. That was my concern. The wall, there's actually a brick cinder block wall behind the front of the property line. You can see it's all solid there, even though there's a sun reflecting on a sheet. I don't have a.
Yeah, I see where it is. But I guess what I'm asking, did that,
About 10 or 15 feet back, that's all solid wall.
Okay.
That was there originally.
okay. So did that lattice fence grow out to the front property line at the same time you built the 3-foot-high fence?
Everything I built there, I wanted to make that gal feel secure,
Okay,
and that was good.
okay. So,
And like I said, you can, it's an extra wide alley. There's, I mean, you get trucks in there. It's just incredible. So there's never been an incident, and hasn't found any, and I'm sure he's looked, of any kind of a problem with that. You can amply see there all the way to the street and across everywhere else. Drive it. You all said you walked by it or looked at it?
yeah, we looked at it. So let me ask you one final question. We are looking at this hedge.
Yes.
This hedge looks pretty healthy. It's been there for nominally 10 years. If you were required to comply with the existing zoning approval, would you simply cut down the hedge and replace it with something, or would you just prune the hedge down to the correct level?
Well, the 4'6" level, I prune it down. I think a hedge is better than, although I could put up some kind of a deterrent type of fence. The hedge is, nobody wants to dive into a hedge. You're going to get all scratched up.
right.
And that's why I thought we'd go with a hedge there anyway. And it's greenery, it adds more
Sure.
oxygen to the air,
Sure.
you know, I mean.
But it could also be, if I'm not mistaken, that's not a hostile hedge. It's something
No.
that, but it could be a hostile hedge. It could
Yeah, if
have,
you tried to-
it could be a bougainvillea or something that has a lot of spines and you just wouldn't even think about climbing over it.
Well, I don't know how many spines are, but it's, you know, it's hedgy stuff. And it's not hurting anybody on the walkway, that's for sure. I keep it trimmed.
Okay. All right. Thank you. Are there any other questions? Okay. Thank you, Mr. King.
I need your help.
Okay, we have one person speaking. We've never seen this person before, but it is Jerry Rubin.
Thank you, Chair, Commissioners. Well, you know, he's asking for help. I think he deserves to be helped. Not just him, but I've been hearing the same concerns, not just recently, but for years from people in Santa Monica. We have a diverse community. You talk about compatible with the neighborhood. If we have diverse neighborhoods, you could have different heights. I think if Bobby Shriver were here today, he'd want to help this guy too. As far as pedestrians, bikes, cars coming down the street, let them just pay attention to stop signs and make sure they stay off the sidewalks. Keep looking at the road. They don't have to look about how high a hedge is to be safe. It's important to take people's feelings into consideration, not just for security, but privacy. Some people, most people, don't want it, but some people do. So I think you ought to revisit this issue and have a more flexible policy. I know it might be a little extra work and go through all this again, but sure seemed to put this guy on the defensive. So he's asking for whatever. As far as incidents, why should you need an incident? I remember when we outlawed bikes on the promenade, no one had been hurt, thankfully, but you want to do something before there's incidents. So you shouldn't have to prove there's incidents to do something. Our place, we have a fence and some nice greenery around it. It helps. One thing, though, I don't like scapegoating the homeless. I'd say most people that are planning to break in aren't homeless. But I do think that if you have some nice green hedgery, and I see things that are way higher than that around the city, no one's complaining. They've been there for decades. And that's the way it is. Some people want them, some people don't. Most people won't, but some people will. So I could really see that you should just grant it and let it be the way it is. He's taking care of it. You don't have to have a dangerous hedge. I could see where someone was walking by and it might hurt them. So you don't want something that's dangerous, but it is a deterrent when there's something high. You're not asking for anything except something reasonable, a reasonable height. My goodness. Why should this be such a hard thing? Why should we be so hard and fast about this in Santa Monica? People have concerns, but I do think Santa Monica is a safe city, and I don't like to see that just be scapegoated like that. I think we're better than we were a few years ago, actually, with the homeless issue and on safety issues, truthfully.
Okay, any questions? Okay.
I have a question for staff. This dynamic, I'm sure, has come up before, where somebody was attempting to fence in their their front lawn, but they were adjacent to an alley, and they have to contend with this 2-foot requirement for their fencing. How have other property owners addressed the goal of creating a buffer but still comply with the HVO?
When I took a tour of the neighborhood, in general, just looking along California Avenue, a lot of them reduced the height of their fences at that 24-inch level. They complied with the HVO. Not all of them did, but most of them that I saw taking a tour of that California Avenue, that general area, the 1-block radius, they were in compliance already with the HVO requirements, and
so, I mean, they comply with what's there within the HVO. Do you see a pattern of applications for taller hedges or fences that are set back outside of that HVO to create just?
I've seen some, not all, but yes, I've seen some of them.
And that they've gone through the process.
Mm-hmm.
And I see. All right, thank you.
Okay, Commissioner Lambert.
You mentioned in the staff report that one option for the HVO remedy is mirrors. Does that take the place possibly of a 24-inch requirement? Because mirrors do a wonder in terms of visibility.
It can, and I've checked with staff in mobility regarding that. In terms of placement of the mirror, there's really no. It would have to be some type of freestanding mirror of some kind, where it would probably block the alleyway in terms of where it needs to be situated for someone to go ahead and either whether it's a vehicle or whether it's pedestrians walking to be able to see to use that mirror as a means of backing out of the alleyway from a safety perspective.
Well, that could be done, couldn't it? I mean, couldn't you put the mirror where the
well, I mean, I don't know where the alley itself. I mean, you would have to situate it somehow where my understanding is it would have to be somewhere like a freestanding mirror of some kind, but that would block the alleyway in the process. I don't know how you would do something like that.
put it in.
You can't speak from the audience.
But I mean, that's what I was going to ask. Yeah. Why couldn't he put it inside his property line?
I think the other thing is when we looked at this is that there's, Commissioner Perry was asking how is this typically addressed when we're at corners. Usually what happens is the fence is indented in, so it's returned in. I think, there are many examples of this around the city. In this case, we saw that there's a different way for this fence to be so that you could still secure the front yard and use the building. For example, if you brought the fence back, 5 feet back, and it connected with the building, that would secure the front yard. And on that side yard, you could do the same thing. You could sort of box it in and then sort of still have the clear triangle on that corner. So, that was a design alternative, that doesn't require the use of mirrors, that would still meet the HVO requirements. So that was part of the, the thinking behind not authorizing this deviation from the standard.
It's very strange because around my neighborhood, there's a lot of their alleys and their garages, and people are backing in, and they have mirrors affixed to their property, to their building. Mm-hmm. They're not freestanding.
Mm-hmm. That is a relatively common thing we see in single-family neighborhoods, because it's typically there's like a garage that's already existing, and those are that is actually a pretty common situation. Right. Where someone's remodeling their house and it's like triggering this requirement. And, we can't require people to demolish an existing building to meet that requirement. So, that is something that has been done. However, in this situation where it's a freestanding fence, and there are alternatives to address this issue, we have really less leeway. We look at the findings that are necessary to authorize that deviation.
Okay, Commissioner Launders.
I have a follow-up question on that. May I?
Sure.
Throw it in now?
Go ahead.
For those, or I guess within the ZA approval, does that apply to the alley side of the front lawn, the east side?
It does, yeah.
So they could go up 4 inches beyond.
Right. So on the side yard, you can actually go up to 8 feet for the fence, 12 foot for a hedge. Within the front yard setback, the limitation is always 42 inches, regardless of whether it's the side or the front parcel line. So yes, the ZA approval did apply to the east parcel line, which is the alley side. So that was authorized, that wall and lattice combination, but it was conditioned to comply with the HVO requirement, because again, looking at that design, we felt that, you know, the fence could be turned in, cornered at the building, and you could still secure, you know, the front yard and the side yard as desired by the property owner.
Okay, thank you.
Commissioner Launders.
So, thank you again. Could we go back to the slides that show the other properties in the neighborhood?
Certainly.
Okay, that actually forward one is good, great. So I just want to try to understand context. I'm new to this. I see that there are a number of existing non-conforming properties in the neighborhood, and when I drove through the neighborhood, I saw what appeared to be sort of I mean, I didn't do real height calculations, but there's some diversity there. And I was not surprised by the applicant, the appellant's other photo from 6th Street, right? So there's a lot going on. I am understanding that the modifications that are at issue tonight were installed quite some time ago, not recently.
Those are existing conditions that are out in the field currently.
I understand.
Okay.
My question, and again, forgive me if this is a newbie question, but are we enforcing equitably? In other words, how did this come to us? Why is it? It's been like this clearly for at least 5 years. Why are we seeing it now? And why are we seeing it and not something else?
Yeah, the case came about, it was a code compliance case. I believe it was a nearby neighbor that saw the hedge and complained about this and filed a complaint with the code compliance office regarding the concern with mainly the hedge issue.
And in the course of analyzing these sorts of requests, not uncommon to see a lot of non-conforming situations. We actually do then submit where we see things that there's not a permit, it's not a registered fence. We actually do submit that complaint to code compliance. So to address your issue of, you know, are things being enforced equitably? If the staff's in the field and they see something that doesn't comply, you know, we refer that matter to code enforcement. We unfortunately don't have the resources to proactively be doing this throughout the city, so it is very much a complaint-driven process. But in the course of our work, if we see something that you know, doesn't comply, it is referred to code enforcement.
Thank you. I'm just trying to understand, because I can understand something showing up and somebody immediately reacting and saying, "Hey, no, you can't do that." I'm trying to understand something that's just sort of been sitting, that's been like this for some period of time, and then suddenly it's where it hasn't been, independent of anything else that's happening in the neighborhood. How is it coming up? So then my other question is related to this setback issue, or the 5-foot issue. Presumably the appellant could put up a mirror, conceivably, right? The appellant could put up a mirror from within his own property. Are there, Jing, you alluded to this, is there something that could be done with that fence on the side that would bring it into compliance? I don't know whether it's kind of chopping off the corner and having the fence be a little bit sort of that shaped. Is there an alternative here that's less, is there a less drastic alternative, I guess is what I'm asking.
You know, based on the applicant's request, you know, he desires to keep the fence at its location, you know, on that property line. So, you know, when we talked with mobility in terms of putting a freestanding mirror in the alley, you know, that would create an additional safety hazard. And it's not, you know, something that we normally grant. And it's, you know, looking again at the findings, because there are findings required to grant that exception to the HVO. Didn't appear to us that was there. You know, in looking at the design alternatives, you know, it seems that there is, like, the height could be maintained outside of the front yard setback up to 8 feet if so desired, by, you know, moving the fence back to where the building line is, and still being able to secure that alley side and also secure the front yard side by, you know, having the hedge and the fence turn the corner as well.
Okay, are there any other questions? Thank you, Ivan. The applicant has 3 minutes to present closing arguments, so to speak.
I wanted to say, originally it was discussed with Ivan on that, but somehow it sort of drifted off into space. I'm more than willing to put up a mirror up there on my property line so it doesn't affect anybody. And what's the safety hazard in the alley? I mean, there is no hazard if it's on my property line, and the mirror can hang out there. We can sure it can be worked out, and that should cover that. That was my original proposal, is that leave the fence the way it is and let me just hang a mirror over there, and that'll cover that one corner, the northeast corner of the property. So that's all I wanted to add. I don't know why that. I never heard more about that. I think Ivan proposed it to me originally, and I got my hand in approval right away. So I'm more than willing to do that. And again, thank you all.
Okay, thank you. Okay, we are ready to discuss in heading towards some kind of a motion. If we want to make that motion, or do you want to do general comments and then find a motion from those?
Yeah, I'll make a motion. I'll begin though by, thanking the appellant for his obvious commitment to maintaining a safe living environment at his property. I mean, that's really important that you're doing that, and I want to say thank you. We have received other applications very similar to yours in similar situations, similar concerns about safety, and in our findings, safety does matter. We need to find that whatever additional height would be approved would be necessary to address those concerns. But we also need to make sure, we have to find that what's being proposed is compatible with the neighborhood, and it's that second point where I find I have trouble with what's being proposed, and I'm going to offer up a motion for the commission to consider that basically falls in line with the ZA's approval on much of the area, but will also for the gate, in my opinion, the height of the gate, the 6-foot high gate, is not compatible with the neighborhood. So I would propose that we find that we make the findings and approve the project at is it 4.5 feet. Was the ZA approval for that we apply that across the front yard area to basically to all of what's being proposed except that wood fence, that wood gate that is next to the building, and that particular item not be approved. So it would be set at a maximum of 3.5.
I'll second it just for the purpose of discussion. The wrought iron fence is what is that what you're talking about? The 6-foot fence on the side of the property?
Yes.
I don't really. I mean, if you drive around Santa Monica, you see a lot of 6-foot wrought iron fences around apartment in front of the walkways to the apartments. I don't have a problem with that. It's recessed from the sidewalk. I think that it's. I think it is a security issue from the standpoint of at least discouraging access to the walkway to the other apartments. So I seconded it, but I would like to see that part put back into the motion. That makes sense?
Okay, any other thoughts?
I guess I appreciate the need for I I'm loath to second guess the zoning administrator here, because the administrator knows the code, knows the neighborhood. I share safety concerns. I believe that I recognize that there are significant safety concerns. I'm always really reluctant to tie that. I just want to make clear, I'm very reluctant to tie that to homelessness, because homelessness and lawlessness are two separate issues. They occasionally intersect, but so do other things intersect. So I hope obviously our city is working to address homelessness issues on a separate basis. But Commissioner Lambert earlier raised the question of consultation with the police department regarding a wide variety of security measures, and I really would want to encourage the applicant to pursue those. And I hope that, obviously the police department's not going to recommend things that violate code. I agree with Commissioner Lambert. I would not necessarily do anything with the wrought iron fence. From my drive-by and from the photos, it strikes me that there seems to be some sort of intent that the lattice fence and the hedge and the side gate all be the same height, which we are all saying is too high, and I get that. I would like to find a way to enable the applicant to opt to move his fence on the side alley to the wall of the building, to address the HVO, given that on the side he has the right to be that high. So I'm not saying that he's going to choose to do it, and if he doesn't do it, then he's got to solve it in another way by lowering the height. But I'd like to see him have that option. I'm not sure how to frame that as an amendment, but I'd like to see him have that option to move that move that fence, if he so chooses.
Okay.
Well, how does that, excuse me, so I want to see the wrought iron fence in, but you took it out, and I seconded your motion, so.
Well, you can make a substitute motion if you would like.
What, do we vote on yours first? Without?
Well,
okay. Then I would recommend that we adopt staff's recommendation, basically, which includes a 6-foot wrought iron fence.
okay.
I'll second that as a substitute motion for discussion.
Wait, so I think you're moving to deny the appeal and support the zoning administrator's determination. Is that correct? That's what you were thinking.
Absolutely right.
Okay. I think that's the way it needs to be recorded.
Yes.
Can I share something too? I just wanted to share a short story. I live in Sunset Park. I live in a single-family neighborhood. And the other night we were not awakened because we weren't asleep yet by a police helicopter that circled our neighborhood for about 45 minutes. And that's unusual in a single-family neighborhood, and there were a lot of police cars. And no one knew what was going on. None of us have fences in our front yard, nor are we going to have fences in our front yard. So I understand the security issues and the fear issues, and basically what we did was turn on all our outside lights, lock the doors, and lock the windows. But I don't think that a fence 42 inches or 56 inches in the front yard would have helped us much. Plus, the police couldn't have seen what was going on in the front yard, which fortunately was nothing. Thank you.
Okay. Commissioner Laundrie.
So I just have a technical question for staff. If we vote tonight to deny the appeal and he comes back and says, well, I'll move the fence, what happens? What are his options?
So if he moves to just comply with the HVO, that's you're just complying with the code. There's no action needed by the commission to do that. If your action, if it's voted and approved on tonight, in order to comply with the action of the commission, it would involve removing the fence from the HVO area.
Right. So he would. I'm just going down through the partial approval. So the 4-6 in front,
and the 6
keeping the iron fence.
Right.
Addressing the question of the wood fence on the side, which would come down to the same height as the internal wood fence would come down to the same height, but then he could choose within code having been denied the fence where it is now, he could choose to move it to the wall
Right,
of the building.
in any number.
And that would be fine.
That would be fine, yeah.
So I just reiterate, I had seconded Commissioner Lambert's substitute motion.
Let me try to frame this in a slightly larger discussion. We're all very aware that crime has gone up, and we also are very aware that people are feeling under siege. So we have to balance that with, on the alley side, there's a safety issue. People driving down the alley have to be able to see people coming down the sidewalk, whether they're 6'2" or a kid on a skateboard that's on his knees. You have to be able to see that person. So it doesn't seem to me to be too much of a penalty, an undue hardship, to bevel the fence back at the 5-foot triangle and keep the plantings that are going to be in that triangle down to 24 inches so that they clearly meet code. I don't think that's an undue hardship. I think a mirror is an interesting option, but again, because you're introducing something that people are not used to looking for at an alley intersection, you're really reducing its effectiveness. It's kind of like if everybody is driving down the alley and everyone knows that to use that mirror, that's great. But that's a multifamily district. People are not that tuned in. There's 1 million people driving up and down that alley. The last thing I'd like to say is the issue of precedence, which goes something like this. I thought this was a very generous settlement by the ZA because, in effect, what we had here was about a third of the lots had non-conforming conditions, maybe 6 or so. 2 of those had actually gotten those legalized, but there's maybe 15 lots on that 2-block area, 3-block area. So we're not even reaching 50%. That is, let's say, in deviation to the current code. So when someone says, I'm going to give you an extra foot to make you compatible, but only a third of the people are uncompatible, that's kind of a generous settlement. That's kind of, sort of breaking the difference in the middle, if you will. So I'm inclined to support the ZA. I don't mind having the 6-foot wooden fence line up with the 6-foot wrought iron fence, because that gives the person in the area that's already somewhat screened out by the iron fence, gives them a little more privacy from their neighbors walking by and looking directly into their side yard, if you will, or front yard in this case. So other than that, I think the ZA did the right thing in this case. Because again, we are faced, this is just very, very chattery. We are also faced with the problem of precedent. Someone comes in and says, hey, I've had an incident, it was even worse than the last one, and I'm really worried, and only 30% of the people are non-conforming, and I want that from my block, and I want that. And the problem with that is it can actually encourage people to start deviating.
Right.
Because if enough people deviate, then everybody gets to have a 6-foot-high front yard fence, and that kind of interrupts the whole thing. So we're balancing conflicting things, and I think this was a good compromise.
So if you wanted to amend our substitute motion to allow the wood gate, I believe that would be friendly to the maker and the wood fence, the friendly to the maker and the seconder.
Okay. Jason?
Well, I may have missed it. What is the basis for maintaining the height of the, or are you saying at 6'10" or you're saying at 6 feet?
I'm saying the wooden fence and the metal fence. The metal fence is at 6 feet. That line is continuous, and the wooden fence is at 6 feet. So that's an element. That's a solid element visually, if you will. Everything else is at 4'6", and it's been beveled back on the alley side to maintain the 5-foot clear, and then there's a 4.
And how does that? I mean, I don't see how that ties into the findings. Like, I don't see how that's justified by the findings or within the findings. And also, the comment was made that other apartment buildings use wrought iron fences. I don't see it on this street. I don't see it within the front yard setback within the street. Now, if they pushed it back to be even with the front of the building, then they're operating to code. But we're talking about something different. We're talking about something that is not allowed in the code unless through this process findings can be made that it's necessary, that it's there to address concerns at the property, and that it's compatible with similar properties in the neighborhood. And that combination, to me, I can't make that finding in the affirmative.
Okay, thank you. I have a question for staff. There was a window where people could come in, as two properties have done, and get an exception. Is that window closed now?
Yeah, yes, it is. It was
And when did it close? Just so.
2005 to 2008 was the registration period, so
I see.
that is not open anymore.
So but had this come to you or the zoning administrator 10 years ago, nominally, before 2008, hypothetically, do you think it would be approved?
If it had been, well, I think
It's like a pre-existing condition, there it was.
Right.
Someone shows up and says,
well, for the registration period, there wasn't really any discretion about it. It was an open time where people could come in and submit as long as they had photos, they filled out a form, they were automatically grandparented to have whatever was there. So there was not a staff determination. It was just an open period to go register. So we have probably about 2,500 of those throughout the city.
so the exception is becoming the rule at this rate.
Yeah.
Okay. So we have a motion on the floor, a substitute motion. Repeating the motion, if I understood it correctly, 6-foot wrought iron fence is okay. The contention is the 4'6" is okay. The only question is the wooden gate. Where do we stand on that? And the 5-foot HOV is HVO is also okay, meaning per.
Well, the wooden gate, it appears, is actually 6'10".
Yes.
So would we want to reduce that to be the same height as the wrought iron gate?
Well, either reduce it to the same height as the wrought iron gate, or as Commissioner is referring to, you'd like it go down to 4'6". So that's really where we're far. That's how far apart we are.
Hard to imagine what that would look like.
Well, it would be one horizontal element, and
And you
then
kind of moot the issue of the gate.
yeah.
May I say something?
Sure.
So, Commissioners, 10 years or whatever it was, there was an enormous furor in the city about hedges and heights, and the resolution was that you would have a fence that essentially would be a legal non-conforming fence or height. You just had to come in and register it, and after that we would impose the code. So the code was put in place. A guy builds a fence and a hedge and a front door and a gate that is non-code complying. Somebody complains. It comes to the zoning administrator who, as Commissioner Perry says, or somebody says, makes quite a generous determination of allowing heights here and heights there, and one of those Delphic situations where you have to make decisions, rules out some elements, doesn't rule out other elements, brings it to us. I'm going to vote to support that because I think it's a clever solution to a difficult problem, but doesn't completely blow up the code. We can't just sit here and go, you know what, we don't like that code, we're just going to take bits of it. You have to make the findings according to what we have before us. I don't understand how you can just say, well, we like that wood gate, but lower it from 6'10" down to 6 foot. And there are certainly issues that people are alluding to in terms of safety. That's a Santa Monica-wide issue that we're going to have to look at with the cops and the homelessness, and resolving the homeless issue and resolving it with the cops. Or changing the code, but that's not what we can do tonight. Your original motion, which supported the zoning administrator's determination, was a good motion. If you're going to keep on changing it, you're doing something quite different. So I would support the original motion. I don't think I'll keep on supporting playing with elements of it as we go.
The original motion did not include the wrought iron. You wanted to take the wrought iron out, right? The gate. You didn't want to adopt the zoning administrator's.
Yeah, he wanted.
He wanted to take the wrought iron gate out. So that was not the first motion. The second motion put it back in.
Your motion supports the zoning administrator's determination.
Precisely.
Correct.
Great. Let's vote on that. I'm calling the motion.
Okay.
Okay. So let's do a roll call vote here, starting at that end.
Commissioner Lambert,
Yes.
Commissioner Landris,
Yes.
Commissioner McKinnon,
Yes.
Commissioner Perry,
No.
and Chair Fonda Bernardi.
Yes.
Motion passes 4-1.
This closes this particular item, and so we are now to the next one, which is the state housing plan, or the recent laws that this is almost a study session in effect to bring us up to speed on what's happening with housing from Sacramento.
Okay, so good evening, Commissioners. This is a study session. We promised a few months back that we would bring you an update on the 2017 state housing package. And I have tonight Andy Agel here, who's our Director of Housing and Economic Development, to also answer questions. I wanted to note that also we handed out a supplemental staff report for this item that should be in front of you on the dais. And if it is not, Kyle can certainly get you copies, and that has to do with, it's there, all right. Clarification of the Housing Accountability Act. So we'll run through some of the bills that were of interest to Santa Monica and kind of, their impacts on Santa Monica housing. So there were 15 bills signed into law last year, and it's all within this vein of addressing the housing crisis, housing shortage in California. And you can see there that it's divided into 5 different categories: funding, streamlining the process, increasing accountability at the local level for the approval of housing projects, inclusionary zoning requirements, and then preservation of housing. So that's how these are divided tonight. So looking at funding of affordable housing, there were 2 bills, SB2 and SB3, and you can see there that one had to do with a document recording fee. So it really was to raise money for the funding of affordable housing, and you can see that the city, we do expect to benefit from this, but it would be likely lower than if it was a competitive process, because it's being allocated through a formula. And if you have questions, certainly Andy can address that. In SB3, this was a housing bond to go on the November 2018 ballot. And the city has not typically relied on multifamily housing program funding. One example of where it was used was the Belmar Apartments at the Village project, which was a public-private partnership. That's the one that's across the street. As city loans are usually accompanied by the 9% tax credits. Looking at the next category, the streamlining, this is SB 35, a bill that was much talked about, when it was going through the process last year. The gist of it is that the bill ties the requirement for a city to streamline its housing approval process based on whether or not RHNA targets have been met. And the Department of Housing and Community Development has been issuing these determinations since early this year, and basically they have a formula, guidelines as to how they determine how cities are complying with their progress towards achieving their RHNA goals. RHNA being the Regional Housing Needs Allocation, which is a target that is established in each city's adopted housing elements. And this is based on the submittal of annual progress reports. So as a charter city, the city was previously exempt from submitting those reports, but this law requires every city in California now to submit those APRs. The city sort of did them intermittently based on eligibility for grant funding and what have you. So we were given a grace period to catch up from 2014 forward. So we are up to date in terms of giving all of our APRs to the state. If a city fails to submit that APR, by the April deadline of each year, it would subject them to the streamlining bill. There's more detail in the staff report or in the info item about which projects qualify for this SB 35 streamlining. Generally, they have to meet, some locational requirement. They have to provide tenant protections. There's an affordable housing requirement. There's a prevailing wage requirement. So there's a variety of things that they have to hit in order to qualify for the SB 35 streamlining, in addition to the city being determined, to have not met its RHNA targets. And you can see in terms of the Santa Monica impact, there's an appendix. I'm not going to go into huge detail into it. There's an appendix to the report that kind of explains, all the various things that would occur if Santa Monica was subject to SB 35 streamlining. So when the first determination came out, Santa Monica was not subject to that. The way that the HCD calculates it is based on, your percentage. You're sort of like prorated progress towards meeting your RHNA target. So in that first review of it, we were compliant with that. And in this, what we're calling the fifth cycle RHNA progress, so we're roughly about halfway at this point. The state determined that Santa Monica was subject to SB 35 streamlining because we did not have enough low-income units produced. And here you can see, I put up the table there from the APR that we submitted to the state. We're at 47.1%. However, that should be 50% or more. This is a point at which the city and HCD disagreed. I am pleased to report today that the staff did get back to us, and they do see things our way. Is that the basically they were not counting under the state law. Very low income or extremely low income units are by definition can be counted under the low income category. So because without that, you're looking at isolating this band of 51 to 80% at the low income level. We explained that to HCD staff, and they have indicated to us that they will be updating their methodology and guidelines. So we'll see with the next determination whether that comes out. Nevertheless, the city is, and I'll show you on the next slide. This is current progress. So this was progress as of the June 2018 determination based on the April report. This is just something that we put together with the help of our colleagues in the Housing Division in terms of, as of August 2018, our current progress towards RHNA. I've included the quantified objective in there just as information. It's not really relevant to the SB 35 determination. But, we are making increasing progress at both the very low and low income level. Historically, the city has not had an issue meeting any of our RHNA allocations. And we've updated it as best we could, but we didn't quite get around to including all of the planning approvals. So as those units work their way through the pipeline, we expect that we will be, continue to be meeting our RHNA targets and therefore not be subject to SB 35 streamlining. In terms of local accountability, the Housing Accountability Act 65889.5 it's codified in that part of the government code, and two bills in there, AB 678 and SB 167, essentially identical companion bills that clarify and tighten the requirements under the Housing Accountability Act. The intent here is really, Santa Monica, as you all know, we do follow, the letter of the law with respect to the Housing Accountability Act. There are many jurisdictions who have not done that, which has, been the impetus for these changes to strengthening and tightening up the provisions of the HAA. One interesting change here was the revision of the definition of what is a housing project subject to HAA. Previously, you needed to have housing units above the ground floor only, and there was a limitation on the amount of commercial square footage that could be in there. So that's been now revised to housing project to where at least 2/3 of the floor area is residential, and it no longer has that above the ground floor requirement. So it's a more flexible definition of what constitutes a housing project. There's also a lower threshold for judicial review, so makes it easier for an applicant who feels that someone has a jurisdiction has acted inappropriately under the HAA. It's sort of lowered the bar, if you will, for a legal challenge, and it, I think, clarified something that we already do, which is provide written documentation to an applicant if a project is not compliant with objective standards. As a matter of practice, the city already does that in terms of our 30-day review letters. We provide not only a determination of completeness, but also a code compliance review for an applicant to point out, when projects don't meet code. More importantly, you can see there that they've added teeth to the Housing Accountability Act in terms of courts being able to compel the approval of housing projects. This is a new authority under this law, and also impose fines on the city. So, I think we're seeing, and we'll talk a little bit about pending legislation, we're seeing going forward a lot more teeth being added to both HCD's ability to enforce, but also, really tightening down and giving, financial penalties on jurisdictions who don't comply with the act. And here you can see with terms of Santa Monica impact, we've talked a lot about the Housing Accountability Act when housing projects come through in terms of the Commission's discretion, with respect to housing projects that comply with the objective standards and those that do not. I've put there that this was just something that the city or the Commission has talked about, really as a discussion, is that, where you have projects that perfectly meet code, does it make sense to have that public hearing process? We have a much more streamlined process in the downtown than the rest of the city in the hopes of producing more housing, and I think the Commission has, thought about that and asked that question in the course of your discussions. In terms of inclusionary zoning, AB 1505. So this really allows, really overturns the appellate court ruling in the Palmer decision. Really giving cities back the ability to have inclusionary zoning in the municipal codes, and also allows, again, you see HCD showing up there with the ability to review future inclusionary ordinances. In terms of Santa Monica, we do have an affordable housing production program. It's supported by Nexus Studies, and it continues to be one of the pillars upon which our affordable housing program is built. It produces deed restricted units when market rate projects are provided. And you can see there that HCD has the ability to review ordinances that require more than 15% inclusionary for 80% AMI or less. And the idea there is to ensure that a city does not establish requirements so high that it impedes housing development. I will note that this came into effect after the city adopted the DCP, so there's no sort of backwards reach to that. In terms of housing preservation, there was AB 1521. This is really an interesting provision for us. It gives a housing organization the right of first refusal to purchase housing in order to keep that housing affordable. So where that kind of lands in terms of Santa Monica is that generally speaking, our local affordable housing, is not at risk of conversion or loss, but based on this was a report that the Housing and Economic Development produced, I think it was a couple years ago, I want to say, where the council asked for information about, what are at-risk properties in the city, and there are a few that fall into categories of some housing projects that were financed through HUD or state loans, and they're coming up on their prepayment or repayment of those terms. There's potentially non-renewal of HUD rental subsidy contracts, and also the expiration of the 55-year deed restrictions. So there are some properties that are at risk, due to any one of those circumstances. This bill provides an additional protection for those properties that otherwise may convert to market rate housing or otherwise. And then to finish up, these are just a couple of bills that we've been watching on the 2018 legislative agenda. All of these have been sent to the governor's desk for signing. They're not law yet, so depends on what the governor does. SB 765, this is the cleanup language to SB 35. So there's a few clarification cleanups in that language, but substantively the bill remains the same. SB 1333, this one, came about, there was a case, Kennedy Commission versus Huntington Beach, where City of Huntington Beach adopted a specific plan that was had far less units than their housing element, otherwise had adopted, and so you had a specific plan that was not consistent with the housing element. This caught the eye of lawmakers at the state level, and so this bill is something we've been following along because it effectively applied planning and zoning laws, general law, requirements to all charter cities, which is one of the things that the city really values is that we believe that we're a good actor in terms of housing, and we really value our local control. We feel that that we produce housing in a way that makes sense for Santa Monica and still does more than our fair share. So we've been following this bill closely because there was a lot of overreach in the original proposals for the language in terms of subjecting charter cities to many planning and zoning laws that had nothing to do with the production of housing. They were reaching into variances and submitting development agreements to the Coastal Commission. There were sort of little oddities in there. So working with the authors of the bill, much of that language has been removed, and I think it's more focused on the production of housing, the things that matter. And it's things that the city does already in terms of we don't adopt specific plans that aren't consistent with our general plan, sort of common sense things that the city was already doing. So, the rest of it wasn't of concern. And then finally, another point of discussion this year has been really looking at all facets of how housing is allocated. As we look at the fair share allocation, so the RENA allocation and the methodology is one that has always been of interest, I think, to many cities who get hit disproportionately with that allocation compared to others. And I think Santa Monica counts itself among those jurisdictions that takes on more than its fair share of housing allocation compared to some other West Side cities. So this is a welcome legislation for us as it adds criteria to the RENA methodology for assessment of unmet housing need, but it also allows the opportunity to have a discussion and to be consulted on the RENA methodology. Previously, our only area, if we weren't, if we wanted to have a discussion about the RENA allocation, it came at the end when we got the number. By that time, decisions have been made too little too late. So, this will hopefully start the discussion about, real fair share allocation among every city, that every city has a responsibility to step up and address the housing crisis. So that wraps, I think, the review of all the bills, and it's an open discussion, so happy to take your questions, and Andy is here, as is Heidi, to address any questions you have.
Commissioner Lambert.
I have a lot of questions about SB 35, which are probably all rhetorical at this point. I want to just say for myself that I'm very disappointed that HCD agreed with us. As I read the RENA chart, we had an obligation to produce housing for people between 51 and 80% of median, and we did not do that. And to say that very low income compensates for that doesn't really do much for the people in that other category because they don't qualify for very low income housing, as you know. So I'm disappointed by that, but who cares? I guess my other question is really how much SB 35 would impact us anyway, because we're talking about projects with more than 50% affordable units, and that would be 100% affordable, and we already streamlined affordable housing projects. So I'm not really sure it would have that much impact anyway, but not that it matters. But there were a couple of points that you made in your SB 35 discussion which surprised me. If a project has city funding, not federal, is it required to pay prevailing wages?
Yes.
That's what I thought. Well, that's good. So the prevailing wage part of 35, if it has city money, wouldn't affect us either. The other thing, there's actually, I did my wonk thing this afternoon and looked up the section of the government code that SB 35 references, and there actually is and in SB 35 there's an allowance for design review.
Yep.
You only have like 60 days or 90 days to do it, but it's not like the streamlined projects would have no design review whatsoever.
I would caveat that with it, that yes, there's design review, but it requires objective design standards. In talking with the authors of the bill, no one actually knew what that meant in terms of what an objective design standard looks like. You know, and we were concerned about that because, you know, we had just been through the downtown process where we heard roundly from the community and from developers that the sort of wedding cake effect and the very prescriptive standards we had before was not desired by the community. So, you know, we have a very different kind of code now that is less prescriptive. So it was a little unclear to us as to what is meant by an objective design standard.
Well, doesn't that correlate with the Housing Accountability Act?
Not really. No. The Housing Accountability Act talks about objective standards, which are like height, FAR, setbacks. Right. When you talk about design standard, you're talking about requiring, you know, how I will set back my building at this level 5 feet in precisely for 35 feet and move. You know, it was hard to think about how you translate design guidelines or the work of the ARB into an objective standard.
I guess to close out the SB 35 stuff, I really would like to see some look at our housing programs and our production policies and objectives, what have you, to include low-income people as well. Because that could be a single mother, working mother who works at the college or the hospital or wherever with 2 kids, and there's no affordable housing for her or him in Santa Monica. And I think that's important that we know that. I mean, yes, we're really producing very low and extremely low, and that's terrific, but there also is a class of working people that are not being served. And there are a lot of reasons for that. The developers choose not to, and tax credits up until recently would not go up to 80%, so they're left out. I really was so heartened to read about AB 1505 until I read that it was only future inclusionary housing programs. If, hypothetically, the DCP inclusionary requirements are redone by the City Council, would that constitute a new ordinance or a new program that HCD would look at?
It's probably something we'd have to look at. You know, I don't know that I know the answer off the top of my head right now. But
how does that review get triggered? I mean, does someone turn this in, or does HCD swoop in, or
it's
the housing police?
Yeah, they are. I will say the staff there appear to be more proactive in terms of their monitoring of it, to the extent that we make headlines when we do something. You know, that may certainly trigger that kind of review. But you know, I think that if we were to do that, I mean, council has asked us to look at incentivizing housing on the boulevards and elsewhere in the city, similar to what was done in the downtown. So conceivably, what we do in the future may fall under that kind of review.
And then I just have a couple more. AB 2162, I don't know if you're aware of that or not, is on the governor's desk, and that would require streamlining of permanent supportive housing, which is what LA has done. I assume this is sort of a model. It probably is modeled on what LA has done. But if that passes, that will affect us. And then there's something really cool. That AB 2035 creates the authority for affordable housing authorities. Do you know about that, Andy? It's like tax increment financing. It's AB 2035. So that's all I have.
Commissioner Landers.
Thank you. So I was, as you were describing it, I was looking up SB 765, which I think actually takes us further down the path of what HCD's interpretation as of today seems to be, because they've replaced 765 clarifies that it's either or below 80%. Rather than both and. I guess my question is, well, it's twofold. So one on legislation, is there pending legislation related to accessory dwelling units? Or is it all gone now?
No, yeah, we double checked just before the meeting with our lobbyists, and
It's all gone,
I think it was
right?
2890.
Yeah,
so
it's
that,
all gone.
that died, yeah.
Okay.
Yeah.
Yeah, they didn't. None of them made it. Okay.
Yeah.
It'll be back. Everything will be back
Everything
next
will
year.
be
I did notice the governor signed something related to healthcare districts. I don't know whether that will affect us, given the number of large health providers that we have in the city. That's on his signing list, from his most recent signing list. This is my question. My sense of the legislation from previous years and from this year, 828, 1333, even 765, we are incentivized to have our policy discussions up front, right? We're disincentivized to make policy or to slow projects down or stop projects or accelerate projects on a case-by-case basis. So from the commission standpoint moving forward, what do you think are the broad policy conversations that this category of legislation is going to be encouraging us to have in advance of housing projects coming to us?
Yeah, and that's, I mean, we've had kind of these discussions swirling probably at the staff level for a while now, and we do have formal direction from the council to look broadly at how do we incentivize housing projects in the city. I think it involves not only looking at and without doing it by raising height and FAR. That is very clear direction that was given to us even in the Bergamot area. So we're looking at that broadly. That involves redoing economic studies across the city. So that's going to take a little bit of time. I think it involves reopening the AHPP. I think in looking at some of the housing projects that have gone through, there has been certainly a lot of concern about the fewer number of affordable units that are produced because people have an option to choose. And really the vast majority of inclusionary ordinances don't have the sort of buffet of choices, if you will. It's usually like one number, and then it's, so we set up the DCP in that manner. And I think it's really going to open up the AHPP. I think it's discussions that the Housing Commission has been having when they recently had discussions about the Housing Trust Fund plan. Those will all be germane to this. We've had there may be opportunities for the Planning Commission and the Housing Commission to be obviously looking at these issues together, because it's an issue that crosses both land use and housing. So I think those are, as we look at it as a staff in addressing the council's specific direction to incentivize housing, I think it's more than just development standards. It's really looking globally at housing needs across the city. And now we've thrown kind of the corporate housing discussion into it, which is, I think, asking us to look at the data in terms of, housing choices across, the many different kinds of populations that we have across the city. And, are we meeting kind of the various needs, given the economy we have, the city of this size, where we are in the region.
Thanks. I think back in 2005, there was a workforce housing task force that Yao Katagiri chaired.
Mm-hmm.
Do you think, particularly looking at the 50 to 80%, we obviously define our affordable housing. I mean, the state goes to 120. We, as a city, have made the decision that we go to 100. But particularly in that 50 to 80% range, is there an opportunity for us to look at what might incentivize that kind of housing? I'm concerned about what some people are calling the barbell or the dumbbell approach to production that gets, we're doing a lot of above moderate, we're doing a lot of low, extremely low and very low, and where we're really getting hit is in that workforce housing it's the backbone of our economy, and we're eviscerating the middle class in Santa Monica. So that's a much longer conversation, but I would hope that there would be an opportunity to look at the range of options.
Mm-hmm. Maybe that's, I don't know if Andy wants to address some of that. I think, certainly there's an opportunity to look at providing housing at every level. In looking at the, what I know about like the master waiting list, it's heavily skewed towards sort of that extremely low income level. A lot of the, we spend our money probably towards where the greatest need is at. But I don't know if there's opportunity to look at the 51 to 80. Yeah.
Just a couple considerations there. So that workforce housing task force, I think one of the reasons it sort of imploded was really strong disagreements about would it be appropriate to take our restricted affordable housing funds and use them for workforce housing, which would end up being much, much more expensive. As Commissioner Lambert mentioned, tax credits, we have difficulty leveraging funds for sort of that middle group, and would we be willing to spend maybe twice as much per unit to create that housing? So I imagine that difficulty will continue going forward. However, particularly relevant to the Planning Commission, there may be greater opportunities when you think about inclusionary housing to address the needs of the folks that 80% and 100% who, you're absolutely right, are not being served by the market and generally are not being served by our programs.
Yeah. I would just also add, apropos of our conversations a couple of weeks ago, another term for corporate housing that I have recently learned is extended stay hotel. I think it's very important that we act expeditiously to protect our residential neighborhoods from that approach to housing, particularly because I would imagine, based on the types of units that are made available to the public, if anything, we're going to be remotely affordable to people at the, say, 80 to 100% level. Those types of units would come the closest, though I suspect they're quite far away as it is. So protecting that housing stock from being essentially abused by corporate bad actors, I think is a good first step.
Okay, Commissioner McKinnon.
When we started the zoning code revamp, mists of time, and then the downtown community plan, I guess one of our stated objectives was to remove a lot of discretion, make it a very predictable process, so that someone who wanted to build something would know right up front what were the costs, tier 1, tier 2, and then if you get to a tier 3, you're doing a DA, so that was a whole other different thing. It does seem that the state has now embraced that in the sense of saying discretion should be removed from local planning commissions, and you should make it explicit up front what the issues are. And particularly in Santa Monica, it all becomes about the zoning now, or the specific plan. Whatever we put down, if someone complies, in essence, if they're on a major transport route or they don't have to do a CEQA, which is most of Santa Monica, they get approved. That is a fair interpretation, is it not? Mm-hmm. Yes? Yeah. So where we now have to focus our attention is not, as the last 10 years of my time and Commissioner Perry on the Planning Commission, of night after night of approvals coming up and us going, well, we'd like you to have a little more height on that building or some more. That comes back to what we encode in the specific plan for the downtown or out on the boulevards or in Bergamot. So that really means we now have to take a thorough look at all of those plans at this moment to see whether it produces the housing we want it to produce. There's no more argy-bargy discussion because there won't be too many development approvals or agreements. Is that the way you see it now?
I think so. I think the, it was, I think somewhat acknowledged by the council that, the approach taken in the downtown with respect to the streamlining of the process, the affordable requirements, the development standards in terms of the modulation. I mean, all of that is it is sort of a, well, let's see what happens, sort of approach. And, they've asked us to come back and report on that. So, to that extent, we are seeing conversions of projects that were formerly development agreements. That was a goal of the DCP, was to, not process development agreements for very typical projects anymore. So we've gotten quite a few applications in terms of administrative approvals that are taking advantage of that process.
Well, and in doing so, those projects have lost height or the number of units to conform with our essentially downsized requirements in the downtown.
Some, not all, no. Some of them are in the transit adjacent, actually, so they retained the 84 feet. They actually got maybe even more stories, because there used to be the 6-story limitation in the 84 code, and in the DCP there is no limitation on stories. So
that can't be that many projects.
No, actually, there's 1, 2, probably 4 that are in the transit adjacent, I want to say.
But it does. So the essential thing is, and there was a line somewhere in the report that you gave us, whether or not the Planning Commission would retain discussion rights about projects even in Tier 2 going forward. So how far along is I think the word you used, swirling discussions amongst staff? Have they swirled to the point where you now think a removal is called for?
I think that's an idea that was presented by the commission. The staff does not change the code by ourselves or policy, so.
No, but
I
you
think
swirl
we've
it
been-
around constantly.
Sure
a lot
we
of
do,
swirling
yeah.
going
There's
on.
a lot
That's
of
why Mr.
swirling.
Agel is here. Swirl, swirl, swirl.
We, I think that's one aspect we've been asked to look at, and I think the commission astutely, saw, you see where the state's going and the housing projects we have, and where they fall within, half mile of transit. I think you're rightly asking the question, in terms of what kind of process do we anticipate going forward. I think all of that is still subject to a public discussion, but that's certainly one of the things that we're looking at, per the council's direction, and how do you incentivize housing. And really you see the framework in the downtown is that there is a significant process incentive to pursue housing, and there's a big difference in the development standards that are applicable to commercial versus residential development. That's not the case throughout the rest of the city, and we kind of have to do the studies to see whether that's a feasible thing to do. We don't know the answer to that yet.
Well, I think there were three elements in the DCP. We looked at the height standards, the approvals, the AA, the difference between residential and commercial, and then there was the parking issue.
Right.
So there were trade-offs about getting more housing as opposed to the costs that were involved in providing what we increasingly saw as excessive housing, housing for cars.
Parking, yeah.
Right, so more for people, less for cars. So will that be part of the policy discussion? And I guess the real issue is how far away are we from you as a group of people coming back with some ideas about that?
I think we're still quite a bit away.
And are we
from
6
that.
months or a year or?
Probably, yeah. Looking in that 6 month to a year time frame, we have other priorities that that in terms of priorities that was not number 1, 2, or 3 on the list when the council directed us to sort of prioritize our work in January. Which is why if it was, we would be doing things now, and that's not to say nothing is happening. We continue those discussions at a staff level. In terms of the parking issue, obviously that is a very sensitive issue throughout the city. So we'll study the issue, and we'll have a recommendation about it. But I'm not sure that we will be able to push it as far as it was in the downtown, given the adjacency to
And I wouldn't
neighborhoods and
argue that, but
concerns.
we do have statistical data now from, I think, 5 years ago, which indicated that moving from 2 cars per apartment down to 1.6 was feasible. And one suggestion would be that you would capture the value of that change and put it into affordable housing on top of the AHPP. And that might produce, so if you change the AHPP, you might get in a typical 40-unit development, which we had here last time, you might get at least a couple more units out of AHPP, and you might get a couple more units out of some tweaking of the parking formula within reasonable bounds. I'm not advocating getting rid of it, but that would begin to produce a lot more. The Memorial Park plan was one we discussed here maybe 6 or 7 years ago, and that was an area where we were looking at some extra value of FAR, up to a half of extra point, I guess, in most of the property encompassed in that area, and then round the train station, that we would look at specific definitions of height and so on, because that's the only train station that doesn't have a specific plan at the moment, and both the others are focused on producing housing and producing affordable housing. How far away is the Memorial Park plan if we're serious about this? I mean, is that now 6 years away?
That is not. Yeah, that one is that is probably, I think, the last priority, if I recall. Yeah. Wasn't that number 8?
And the list is what, 23 items long?
It's 8 items, yeah. In addition to the existing work we have going on.
So a couple of years, right?
It's not a immediate priority.
Okay. Could I ask Mr. Agel a couple of questions, if that's possible? So, one of the other areas of producing housing, given that we're a wide-ranging discussion about housing here at the moment, is that it does seem to me that the real issue in housing, in producing affordable housing, is the cost of the land. And the cost is extraordinarily high in Santa Monica because of the demand that's here. If we can get past the cost of the land, is it possible for affordable housing producers to leverage tax credits, some slight input from the city to produce substantial amounts of affordable housing?
Yes, so when we're making loans for affordable housing, and talking specifically now to new construction, the city typically funds the entire land acquisition, and then we fund a small portion of the construction, and typically tax credits and a bank loan will pay for the bulk of the construction costs. If we were to take advantage of land that was free, for example, so let's say city-owned land, we could stretch our city dollars much, much further and produce much more housing.
So let's talk about that for a minute. There are three government entities in Santa Monica: the school system, SMC, and the city. So the schools have had a change of one of those AB numbers you guys probably know, 64, 32, 45, whatever you know it better, that they can now leverage tax-free or tax-enhanced situation. So the school system, which owns substantial land along Colorado Boulevard, which they didn't collect rent for a long time, but certainly around the Memorial Park area, could look at both of those as an example, couldn't they? I mean, they've always talked about workforce housing. They have a large workforce that now drives in and out of the city every day because they can't afford it, starting at $48,000. So is that a possibility?
That's a possibility, and it has been done in school districts in California.
Would SMC be in that category?
I don't know if the legislation applies to community colleges.
So let's come to the city. The city owns considerable amounts of land, if nothing else, the Big Blue bus site. Just the airport would be one, but let's not talk about that. Let's talk about what's achievable right now. The Big Blue bus is adjacent to a train station, which is essentially where I'm thinking. It has transport links and it's got all the superstructure in place. Is that somewhere where we could look at doing a deal to start producing these levels of affordable housing we're looking for?
So I think there could be opportunities right along Colorado. I think I'd be nervous about the bulk of the Big Blue bus yard.
I'm not intending all of that,
but if you look, the strip along Colorado, I think could be a great opportunity for affordable housing.
Particularly senior affordable housing because it's a walkable community.
Could be senior, could be special needs. There's great needs in the downtown.
When the parking people came to see us, led by Henry Severin, they indicated that parking demand in the city had dropped by 7%. And it does seem on the trends that Uber and Lyft driving is up, but people coming and parking in parking structures is well down. And so that we have, 60,000, whatever it is, number of parking spaces, but the requirement on that's diminishing. Does that lead us to believe that one of those parking stations could be converted to affordable housing relatively soon, instead of, for example, retrofitting it for seismic?
So I do think that is a real possibility. And as you know, when the city built parking structure 6, it essentially replaced the parking at parking structure 3 or 1, whichever you want to consider. So that could absolutely be an affordable housing opportunity. And I'd suggest you not just stop with the downtown parking structures. There are surface parking lots that the city owns throughout the Santa Monica that could be housing opportunities as well.
Right, so parking structures, surface parking lots through, and then of course we have the granddaddy of all development sites, 4th, 5th in Arizona. If you, as I am sceptical about the economics of the numbers stacking up from what we've seen, would that not be a good place for affordable housing right in the middle of the downtown, nice big open green space area and so on?
I think anywhere downtown is a great place for housing.
Very, very diplomatic response, Mr. Agel. Nice sidestep there, I think. So I guess what we're looking at what I'm seeing is that we have some issues with zoning and specific plans where we as a planning group and the City Council need to look at more inclusions and more opportunities and look at the trade-offs. And then second, have to focus on land that we currently have. Do we need as a planning commission to take any action on that, or is that beyond us?
So right now, the Housing Commission is spending a lot of attention looking at issues specifically of how can we reduce the cost of creating affordable housing. And one of the specific issues they're looking at, in fact, they took it up in our last meeting, was looking at what are the city-owned properties and what potential might they have for affordable housing. So if you're interested, we can share it with planning staff and they can share it with you. We put together a map of all the city-owned properties. And
that would be an excellent
Housing
idea.
Commission's looked at it. Some of our nonprofit affordable housing developers have looked at it, and we're with the hope that eventually we'll go to council with some ideas and get some direction from them.
And finally, I didn't want to dismiss what the gentleman was saying earlier on about the issue of homelessness. The way he tackled it, I thought, was completely unreasonable, to be honest, and the way he ascribed security issues to homeless people without any evidence. But nonetheless, there are considerably number of homeless people in the city that are sleeping. What can we do to tackle that crisis, and do we need to formalise it in policy?
So I think the city's got pretty good policies, and as
Yes.
you know, that creating housing is probably the best tool that's out there to address the issue. Creating permanent supportive housing, I should say, and that is that's mission critical for the housing department, housing division, and in fact, council recently adopted a spending plan for our housing trust funds, which puts a priority on creating permanent supportive housing.
Are there any other areas we should be thinking about or looking at right at the moment that fall within our purview?
So I just say generally, since you're ultimately responsible for planning and zoning, that is an area where it makes a difference in the cost of creating housing. So we provide, as a city, we provide additional FAR and height for affordable housing. Anything else we could get would help. Our nonprofit partners are competing with market rate developers who can pay a lot of money for land, and every little additional allowance that goes for affordable housing helps make our nonprofit partners more competitive when they're competing for land.
So, for example, there was an affordable housing project on 14th Street. So if it had had an extra 0.5% of FAR, would that have made a considerable difference to that project?
Yeah, in that case, it wasn't FAR that was the limitation. It was height. There was more available FAR, but the height limit meant they could go up one more story, go from 2 stories, sort of the general for market rate would be 2, they could go up to 3. Had they been able to go up to 4 in that case, we could have produced a lot more housing, and the per unit subsidy from the city would have dropped quite significantly.
That would probably have fallen into the Memorial Park area.
I don't remember the boundaries. I'm not sure. It's sort of
Another
on the
diplomatic
other,
answer,
on the other
Mr.
side
Abel.
of the cemetery. It's
Yeah.
I'd say it's close,
Other
but
side-
maybe not
yeah,
quite in the
maybe
area.
not. And I guess the other thing we could do is just put more money into affordable housing from the city. The city could contribute through its budget, which it should be doing, but that's a whole other discussion.
Yeah, just not to leave that. The council did commit over $70 million of general funds toward affordable housing. So
I totally understand
don't want to
that.
give short shrift on that. It was a lot of money.
Thank you, Mr. Agel.
So if I may, I just want to caution the commission that really your agenda item was to discuss the 2017 housing package. So I just want to remind you that
Heidi, you have
Remind you
blotted
that-
your copybook right there. You were doing so well for so long. Here we are, hours in.
that to the extent you would like to have a more robust discussion about the specific items you're asking Mr. Agel, perhaps it would be more appropriate to agendize that for a future meeting, since before you this evening is the state housing package.
Okay. Commissioner Perry?
Yeah, earlier Commissioner Lambert took the bold position that she wishes that the HCD had not gone along with our interpretation of the well, basically said that the city was in compliance. And I'm not as courageous as she is, but I would like to share the general idea that we certainly, regardless of what's required of us in Sacramento, we need to identify those segments of our community that we need to preserve and expand to develop the diverse community that that we want to be. I want to just get clarification. I suspect I know the answer, but the way that it is crafted in the DCP, our affordable housing inclusionary requirements, the DCP does not take the approach that an extremely low unit would qualify as any other income category. Is that correct?
Yeah, we require it across the spectrum, if you will. So you don't get a choice. There's a number, and then it sort of divides it up. And that was based on the proportions within the RHNA. Right. And that was really getting at producing housing at all levels. So I think that the city believes in doing that. So we try and pursue it. We were just concerned that for the purposes of this particular calculation, this formula, it seemed to be incongruent with what the law otherwise allows.
Right. But in terms of applicants coming and proposing projects, they would have to be right in that specific income category.
That is correct.
Yep. Right. And I was able to give a really quick look to the update we received on the dais regarding the Housing Accountability Act. Mm-hmm. If you could please elaborate on what projects that come to us, what the significance is that those projects that where the application is deemed complete, that there is some non-compliant aspect of their application, or they're asking for a modification, what that means for this body's consideration of their proposal.
Well, I will start off, and if the planning manager would like to jump in, she's free to. So generally, when the application is determined complete, the project does not meet all of the city's objective standards, then the Housing Accountability Act does not apply, and this body has full discretion with respect to the project before you.
So then practically, when an applicant is developing a proposal, how often do you find that at that point at which the application is complete, there are little things hidden that where there isn't compliance, that the applicant didn't quite get it right? Is that frequent? Does that almost never happen? What are we looking at? So
I'll have to defer to the planning manager on the frequency of it, but the general idea is that staff does work with the applicant along the way so that they are able to make an informed decision by the time it gets to hearing on the applications that they have filed, should they request a major modification or variance, and that if they are making those asks, then the Housing Accountability Act does not apply. But they could make revisions to the project along the way to make it code-compliant.
But they would not be protected under the Housing Accountability Act. If after submitting the application, they're modifying their proposal.
So that's an excellent question, but I think by the time they get to hearing everything is code compliant, then the Housing Accountability Act would apply. So it's by the time it gets to hearing what the applications are before you.
Got it.
Can I ask a follow-up just on that point? So we have a project coming to us next month. We'll be reporting ex parte meetings. I had an ex parte meeting with the applicant, and one of the things that the applicant stated to me in the meeting was that if the two variances are approved, that the project becomes an AHAA project. So they're walking in with the expectation of the prior interpretation of the law. I'm just wondering given this interpretation, which I understand and appreciate in terms of giving the Planning Commission a little bit more discretion, are current pipeline applicants being made aware of this change? Because they're going to walk in with the expectation that the minute those variants are considered, and if they're granted, that we move into HAA land. And what this, I understand your memo to say, is that's no longer the case.
Yes. So we will be working with planning staff to coordinate to ensure that all applicants are made aware of this. I think practically speaking, I'm not sure if the commission was so inclined to grant a variance or a major modification. It is not clear that after that point you would be inclined to either deny the project or to reduce its density. So to that extent, I'm not sure that practically speaking it's going to have a large effect if you are inclined to grant those major modifications and variances.
Sorry, I'm just asking so that when we have applicants showing up, they're not surprised and they know this before they walk in. I'm not suggesting a change to any right. It's just that they said that they know before they get here.
And in the staff report, there was some discussion about just that general question of, in the context of the Housing Accountability Act, and maybe some of this new information changes the discussion, but there is a question of, well, why do we have development review here at the Planning Commission when the applicant has rights to create the housing that they're proposing within the narrow limits in state law. And you know, as I look at it, that's a question that has occurred to me as we're sitting here hearing those things, and the answer consistently is massing, the location of massing of the project. And you know, if indeed that is going to be the kind of the remaining focus within our work for at least looking at DRPs, then perhaps we need to consider some changes in how we do business in this context where an applicant is coming to us with rights to create this housing, and we are extremely limited in our ability to say no. That we need to have a way, I believe, to say yes, but with changes in massing, which is a difficult thing to achieve here up on the dais, where we'd be talking about making changes to a very complex proposal. So I don't know what the answer is, but I want to raise the question, or add to the questions that are being raised. What could we do, both as a commission and as planning staff, to equip this question of how does massing get addressed in the DRP process?
So the DRP process allows for, or requires actually, a concept review at the ARB, and we spend actually a considerable amount of time with applicants and our design and preservation planner going through design of a project, site design, massing, all of the elements that are findings for a DR. We spend a lot of time with applicants going through that before the commission ever sees a project. And I think that we've seen really good outcomes actually out of the ARB concept review process, as the board has kind of embraced that role more and provided feedback to applicants. Applicants have appreciated having that feedback before they have the formal design review in terms of shaping all sides of the project, whether it's the materials, the texture, massing, what have you. The commission, really does have the purview to deal with all of that, but within the context of, as long as it doesn't result in a reduction in density or number of units in the project. So, as you recall, when we've imposed those sorts of conditions, it's with the caveat, and that's usually added on, that the applicant will look at that as long as it doesn't result in the loss of units. And I think that applicants have, where it's reasonable, they found a way to sort of move things around. And, we do the same work at the staff level to encourage, balance the desire for livability and open space and units and what have you. It's like, did you think about moving things here? You're still not losing the number of units you wanted, but it maybe, gets a little more natural light into this, that, and the other. And, I think that has been helpful feedback. It's resulted in better projects, and it hasn't resulted in a loss of density. So, I think that early design review function is a valuable part of the process, and we present those recommendations to the commission as part of the DR review.
Yeah, and I agree with where we've been so far. Mm-hmm. I also have the general sense that we've been dealing with applicants that are acting in good faith, and I just question, somebody wanting to test, how far they can go with this in order to produce the most economically viable project they can. Mm-hmm. What would we be able to do in that scenario, particularly in the context of the Permit Streamlining Act? Mm-hmm. We're even limited at times in continuing a project. Mm-hmm. So it's that scenario that concerns me more than anything that that will be tested.
Yeah, and I think that we will certainly learn a lot out of the projects that are going through the DCP process right now, because those do not have any public hearing. They are only required to precisely comply with the downtown community plan standards, the modulation standards, and what have you. And that's why, I noted that was adopted by the council with the caveat that let's see what happens. And, we were told by the design community and, by developers that if you gave us more flexibility, we could do nicer buildings and produce housing and this, and if the outcome isn't, we're not getting the outcomes that were discussed, in the formulation of the plan. These are living documents, those are the things that can be changed. But it is a little bit of an experiment, and providing a streamlined, basically plan check process, right, with some standards that apply. There's guidance, within the plan, pretty clear about what's expected, and kind of seeing, what happens with that.
Okay, I have a few comments. First of all, thank you for this document. It's very valuable. It is crystal clear in its questions, really, because a lot of things are the law of unintended consequences. We won't know until they roll out. But there are some things that were a little curious. In the first one, the Senate B2, which suggests that we're not going to get the full benefit of this particular one because of some competitive or non-competitive things where we're using federal allocations. Maybe Mr. Agel can speak to this. What exactly is that?
So we absolutely will benefit from SB2, but one of the points there is it would have been more advantageous to us if those funds were allocated on a competitive basis. So let's say we've made a loan to a nonprofit and they're competing for funds. Mm-hmm. We tend to do very well in that competitive process. The way the legislation is written is the bulk of that funding that goes to cities will be on an entitlement basis, which follows the federal allocation process for community development block grant primarily. And some of the key elements there for how that's allocated is poverty, overcrowding, those types of things where we don't do as well as opposed to some of the
because
jurisdictions.
We're a wealthier community and we lose points presumably.
Yeah,
in
so we're an entitlement
Mm-hmm.
community now. We get community development block grant through the federal government. We just will not see as many funds as we would have if it
Got
was
it.
actually
Got
on a
it.
competitive
Okay.
basis.
That explains
It's
it.
still going to be beneficial. Don't get me wrong.
Okay. Who exactly compiles the RENA numbers? Which body actually does that? Who are they?
The allocation really is given by SCAG, at the Southern California Association of Governments. Yeah, well, it comes from the state and it's fed down through the regional governments, and then it's allocated through a mysterious process that you end up with a number at the city level, basically.
Sure.
So my follow-up is, why do we have such high numbers compared to communities around us when we have delivered so much affordable housing over so many years?
Yeah, so to be very frank, a lot of that process is it's politics, at the moment, and it's almost a situation where as cities, it's the more housing you produce, the more that you will be allocated. And
No good deed goes unpunished.
And if you're a city and it's tied very much to transportation funding, so if you're a city that welcomes the Expo Light Rail and Rapid Bus and all kinds of transit, and you're a city that doesn't do that, then the formula as it is right now basically says, well, you don't have a lot of frequent rapid transit here, so it's not a good place to put housing, but the city that takes it on gets a disproportionate share. And that's where some of this pending legislation may help with that methodology and evening out and sort of taking the sort of politics out of it, if you will. And it's why, Santa Monica continues to produce, but, we're maybe not seeing that. We'd like to see other jurisdictions, in our region kind of step up to the plate as well.
Commissioner Perry. Okay. Well, while I got you here, Mr. Hagel, could I take advantage of this? About, 3 or 4 years ago, you gave a very comprehensive report on the status of housing in Santa Monica, and it was the salami was sliced in all the different ways that it was important to slice it. And it was bad news, basically. How long ago was that?
So I believe that was 2015, probably.
So
soon after you may recall there was a ballot measure to create funding for affordable housing in 2014 failed. So we went back to the drawing board in 2015.
Right.
That ultimately resulted in the GSH on the 2016 ballot. So in that regard, I'd certainly say we're in much better shape than we are then. We have a local permanent source of funding for affordable housing.
Sure.
The state has now adopted a permanent source of funding for affordable housing. We've got, and it's not just us. I mean, what's great, this is a California problem. We've got the city of LA, we've got the county of LA, we've got several counties and a few cities who've done what we've done and gone to the voters and said, we need to focus on this issue.
Okay. And if you were to produce the same report today with the same level of detail, it would be a triennial report. Would you see the needle moving, or is it still too early to see all the effect of the DCP and all the work that's been happening over the last 8 years, 5 years, 3 years, including the funding now that we're collecting some of this money? When do we see the needle move, or is it already moving?
Well, so it's definitely moving, but I do think we're still a little bit early in terms of seeing the actual. So this has been a good time to build the infrastructure, both on the funding side and the regulatory side. And so I think we'll see, particularly in terms of greater affordability, come to fruition over the next 3 to 5 years.
Okay. Last question. Is every county, charter city, non-charter city, is everyone governed by the RENA numbers? Everybody has been given a number to meet.
Everyone has been given RENA numbers, though, as Ms. Yo identified. It's not been a great process. I think the poster child. So the legislation that's in front of the governor now is really important. I mean, the poster child was Beverly Hills, right?
Sure.
4 units.
Right.
4 units. And they have no jobs and they have no transportation, right? So, I mean, that was the perfect poster child for why the system's broken. So dealing with that, including that legislation gives independent organizations. So you could see an organization like Western Center in the future saying, how come Beverly Hills has 4 and Santa Monica has over 1,000? I mean, it's so I think that's going to help a lot. And just letting SCAG and all the other cogs know everyone's watching. We better not have this going forward, because there are going to be immediate lawsuits or what have you to say, how did we end up where we ended up the last RENA cycle?
Okay, thank you. Any other questions, comments?
I just have. Your light's not on. Yeah, but your light has to be on too. I just
Rookie mistake.
Let them just talk amongst themselves. They'll resolve
you'll
it.
learn.
Have a fist fight and let us know who won.
Sorry, that's not on the agenda, Commissioner.
Sorry,
But just in closing, I want to thank you all for doing this. I would love to have more housing discussions like this in the future. And a couple of things I just want to say finally. I welcome the state's intervention on housing issues. We may be a good actor, but there are a lot of bad actors out there. And I think that's why now the state is getting involved. And having gone through the death of redevelopment fights, which redevelopment lost, that was because there were a lot of bad redevelopment actors. And I think that's what we're seeing the state now stepping in and saying, okay, you guys, whoever you are, who are not performing. I mean, I heard the other day that only half of the cities in the state now have ADU ordinances, despite the ADU law. So that's that. And this does kind of relate to the incentivizing affordable housing. I would love to see us at some point in the future, and I know you're busy, of looking at applying density bonuses to properties that don't define development max as density, specifically to FAR. I mean, how would you apply a density bonus to an FAR-controlled property? I know it's done elsewhere, but it would be a way, I think, to incentivize more affordable units if that existed. So in the future. So, it looks like I wrote hormones. No, that can't be right. And then home ownership opportunities. I think using city land for home ownership possibilities, Andy. I mean, if they are ever going to exist in the city for low and moderate income people, it would be on city land where you control the price of the land. You could write it down to zero, and so that theoretically the housing unit would be affordable to working people. That's it. And thank you all.
So, bearing Ms. Van Tongel's request that we stay on the agenda in mind, I'm going to frame my question this way.
Commissioner, you really are new here. Just go right ahead. You do whatever you want.
Does the state 2018, well, for Mr. Agel, with respect to financing, as state legislation and regulation has evolved with respect to ADUs, what are the current barriers to the city potentially financing ADU construction in exchange for affordability covenants? Which I know is an idea that has been mooted.
I don't know if they're strict. I can't think of a strict limitation.
Okay.
There'd obviously be some pretty considerable trade-offs in doing that. But I wouldn't, for the sake of thinking broadly, I wouldn't immediately take that off the table as an option. Okay. We're in a place we need to look at all options, and if there's a way to do something more efficiently, more effectively, that could be an opportunity.
Okay. Sometimes legislation is of interest to us that doesn't pass. As you mentioned with 2890, and bearing in mind our obligation as a commission to be making recommendations, is there legislation that got close to the finish line, whether it was housing legislation or related legislation, that we ought to know about because it's going to come back next session and we ought to be looking at it?
I think everybody is expecting that the SB 827 will come back in some way, shape, or form. The authors, obviously learned a lot going through the process. There was a lot of input given in shaping that, so I think we're expecting in the next legislative session you'll see something swirling around that particular.
And Senator Wiener has said that expressly, that he's learned a lot. He's going to start with more of a grounds-up approach, work with folks who are opposing it, who wouldn't necessarily oppose it if it crafted in a different way. So I think we should expect that coming back, absolutely.
Okay. And I assume there'll be an ADU. They'll try again. Somebody will try again with ADU legislation.
I I wouldn't doubt that.
Okay. And then my last request is for a future, this is very helpful, and I think it also could be very helpful for us to have a similar presentation on mobility legislation for a future meeting. So if I could make the request that
That's our next agenda item is future agenda.
Fantastic. Okay.
Okay. Hearing no other additional comments, I think we beat this one to death as far as we can realistically with the information that we have. So I think it was a very productive study session, and thanks for the setup, and thank you, Mr. Hagel, for coming and giving us some other feedback from the other side. We're on to future commission agenda items, and I would like to frame this discussion in a slightly different way. Usually we get to this point and we're exhausted and we want to go home, and but you know, the way to avoid these long drawn out study sessions is to put things on the agenda far enough in advance that people can think about them and get ready for them. And therefore I would argue for not canceling planning commission meetings just because we don't have a project, but we use the kind of holes in the Swiss cheese to develop our own education and improve our own understanding of these very complicated gears and how they're supposed to turn together. And so I'm entertaining from you all, which you've already started this process, and hopefully the minutes will collect all this information, is you all have particular passions and interests and questions. Let's get them down, and then let's schedule them for this is the one where we have a light agenda on that particular one. We can bring that to the fore. Now, not all of these will involve additional work for staff. Some of these will be questions for the Housing Commission. We bring them in. Some of them will be questions for the Building Department or the Fire Department. I don't know. They're going to be broad questions, but I would like to start basically stepping up our game and becoming more knowledgeable about decisions that we're going to be doing. And you can just see just the amount of effort it takes just to get it right in housing. The same thing applies to mobility and all that. So let's go around the room. Give me your top two.
Sure, I have two. My first one would be the mobility legislation piece and continuing updates related to mobility legislation. My second, I don't know if you've done a lot of thinking about this new scooter technology lately. It's late, but given the development of the scooter pilot and the e-bike and the shared mobility pilot more broadly relative to bike share and other things, I would love to have a study session that looks at innovations, opportunities, challenges, barriers to zoning relative to those devices. That could include low-speed lanes. That could include circulation strategies on different streets. What's the range of policy making that we could be looking at relative to these new forms of transportation, getting people solving first mile, last mile, and ensuring safety both on the streets and on the sidewalks?
Okay.
That could be quite a long session, Commissioner. I think you could start working on that for the next 5 years, and jing, off you go. But there's certainly elements in that. There are a couple of things. First, the Transport Management Organisation, TDM, is something we've written into every single DA and has been part of every development review. It's part of the zoning code. We've actually never really considered it here. We've had two presentations from the mobility manager that, you know, I timed them out when I reviewed them at sort of 45 minutes, and then she extrapolated at some length. We never actually got to speak to the people involved in running it, who it turns out are consultants. And so it would be extremely useful, as they have now prepared their annual report or biannual report, to have an analysis of how it's working on the ground. Is it working properly? They've done the report. That can be the basis of the report to the Planning Commission, so we can get some understanding of whether or not that needs to have further analysis along the lines you're talking about. So that would be a key moment, and I think further issues on mobility are called for, whether it's as expansive as the first topic or we bite off chunks as we go. I think that's really, really critical that we do that. And I completely agree with Commissioner Fonda Bernardi. A year or so ago, when we had the DCP, the city manager, then city manager, current city manager, Mr. Cole, said, So the Planning Commission is going to get into planning now. I think you'll remember that. We were all at that meeting together. And this is the moment for us to start. We can't keep cancelling meetings. That's not a good idea. And these are the things that we could be talking about that are real planning issues. My second top thing is, having thought about it, is the private tree legislation. So we had an environment study session here that now must be 3 years ago. The issue of losing trees on private land, we have, I'm wanting to say 30,000 in public hands and maybe 36 at one stage in private hands. It's diminishing rapidly. That moment, that time has come. So they're my top two.
Thank you.
And by the way, Commissioner, you've done a great job as acting chair here this evening. I'm
just,
supporting
I'm
you.
just acting.
I'm going to support you for the chair's role.
Two areas that that come to mind. The first is my understanding is that city staff is currently working on the next round of climate action and adaptation. Is that accurate? I would like to. I mean, I don't think it needs to wait for that document or whatever stage that they're currently working on in order for us to have a broad discussion of kind of this next level that we all really need to take. So I'll put that forward. And the other thing that came to mind just slipped out of my mind. I won't give it high priority. I won't suggest high priority, but I think that it is incumbent upon us to explore this charter description of our role in public works, and to go through a process where we are understanding what it means, how we might apply our understanding of that responsibility that we have in a way that is constructive, the one that is helpful to the city's existing process of moving forward on public works projects.
Okay. I've got two that are low-hanging fruit. One is I'd like an update and a status report on our seismic upgrade of the city. One of our responsibilities as Planning Commission is to provide for the health and safety, and that's one of the biggest threats that we faced. And then the other big threat we face is the continuing diminishing of water. So I'd like an analogous study session on water neutrality. How are we doing? How can we do better? Blah, 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 blah. So those are two easy ones that, just involve, in this case, getting the building department in here and getting the water neutrality people in here and tell us what's going on, bring us up to speed. So, please.
Sorry. So next September 13th, I believe, I will be attending, and possibly other commissioners will be attending, a conference that was circulated to the Commission. To the extent that we're not overburdening any particular agenda, I think as commissioners go to conferences, another way of keeping our is sort of what I'm not sure what the procedure is, but I assume that when we go to conferences we report on key learnings. No? Perhaps we
just
might
keep it to yourself.
Oh, sure. Okay. Well, I mean, that just might be another good use of time just to make sure that we all get the benefit. Yeah.
Okay. So
you can really see he's a new boy, can't you? All these interesting ideas.
Okay, I think we've reached the end of our rants here. Any other written communication? Anything that we have to respond to in any way? Public input? Some people have stayed here a long time. No public input. Then I move that we adjourn.